Hello, I'm troubling you all with a very short complaint on the way in which academic discourse is done in India. A few months back, there was a decision by the Supreme Court in Southeast Asia Marine versus Oil India Limited, where the Supreme Court decided on the issue as to whether an increase in diesel prices, which are which at least were at that time were notified through government notifications, amounted to change in law or force majeure, thereby entitling the contractors to invoke the force majeure or the change of law clause in the contract. The Supreme Court interpreted the contract and also analyzed the provisions regarding force majeure and came to a conclusion that it cannot be. Now, what the Supreme Court is settled the law that was not settled before. Practitioners would vouch that in numerous contracts, including construction contracts, increase in diesel prices as amounting to force majeure or change in law is one of the prominent grounds or claims that contractors do. More often than not, they are successful in the arbitrations. The Supreme Court has therefore ruled on a very important point which settles the law. Till now, I am not sure if there was a decision of the Supreme Court on this particular issue. So that is the background of this particular judgment of the Supreme Court. But I see so many blog posts and articles and even law firms write-ups criticizing the judgment, saying that they should not have set aside the arbitral award. Now, had this arbitral award not been set aside and had not the Supreme Court clarified this issue, what would have happened? This question, which is, like I told you some time back, a very prominent point that is raised by contractors in numerous contracts. This point would have remained unsettled, and the courts would have continuously been faced with arbitral awards, with petitions for setting aside arbitral awards on this very particular issue. Now, Supreme Court has finally settled the matter. You see, arbitration does not have two horns that it should be treated as if it is some kind of thing having higher sanctity. No, arbitration is a process of resolution of disputes, right? But if arbitration comes in the way of development of substantive law in India, then of course that should take a lesser precedence. Now imagine the cost implications. I'm not talking about just the cost of the parties, but then of costs that would have been incurred had this question not been decided. Had this question not been decided, every time contractors would raise a claim. Number two, the tribunal would be faced with this question, and the parties would have to argue. The councils would have to argue. Imagine how much social cost will be imposed had the Supreme Court not settled this. Therefore, please do not write such articles simply saying that no, so the Supreme Court was wrong in setting aside the award and all that. I request you all to engage with this particular point I said just now. Now, having engaged with this particular point, if you still maintain that the Supreme Court was wrong and setting aside the arbitral award, that is fine. But without engaging on this very important point and simply parroting the Western discourse that arbitral awards are not to be set aside, there is no absolutely no point. Look at English law, where English law has a ground for by which it can set aside arbitral awards on account of error of law, right? So there have been in the past numerous concerns raised by several scholars that arbitration may come in the way of development of substantive law. And in India, if you notice that there are not many decisions on contract law addressing various situations. So Indian contract law is in a nascent stage. Apart from the Indian Contract Act, you do not find many judgments of the Supreme Court or the High Court settling important issues. Therefore, it is extremely important that the courts settle the law, right? And if arbitration comes in the way of court settling the law, then of course substantive law has to bring precedence. Law should be certain. That is the most important thing. Especially in commercial law, what happens is if the law is not certain, then parties tend to waste money, I'm sorry to say, on lawyers and unnecessary litigation, right? Now, after this judgment, nobody will unnecessarily raise a question on this. Nobody will unnecessarily raise a claim on this. So it saves a lot of social costs. Kindly see from that angle and just don't have a unidimensional approach as far as criticizing judgments of the courts are concerned. Appreciate the law, appreciate practically why a judgment has been given. And you can also research in the past on whether the Supreme Court or High Court has decided on this question from a substantive law point of view. Kindly do that. See, this Schrodinger's cat example. So, while explaining quantum mechanics, I think so. The Schrodinger it's a kind of a thought experiment. So, where there is a cat in the box. So, what used to be said is whether the cat is there inside the box or not is a question that cannot be concretely answered insofar as quantum mechanics is concerned. So, the law as it stood before the judgment by the Supreme Court was like a Schrodinger's cat. Now we all know that Schrodinger's cat is inside the box, so therefore things are certain. Kindly do not just due diligence, but also think from a larger perspective while dealing with arbitration. Arbitration cannot exist in isolation, right? It has to exist along with the substantive law and all other procedural laws. Thank you. For a detailed discussion of this problem, kindly see the blog post in the Practical Academic blog, whose link has been given in the description. I would invite uh, people who are interested in this issue to write to me either in the form of the comments in the YouTube post, or you can mail me at lawbadri@gmail.com, lawbadri@gmail.com. We can discuss this further. Thank you so much.